Anybody have any questions about anything?
This is from the test.
Yes.
I have actually a few, but I'll just ask one.
Sure. You can ask as many as you want. We have time.
The main one that was making me confused. Okay, if you negotiate your percentage, it's number 19.
Okay, I don't have the test in front of me, but that's
Well,
okay.
anyway, it talks about this person who listed this property
Okay.
and then sold it. And
Okay.
they negotiated, at first they said a 5%, but if I sell it, then it would be a 4%.
Okay,
Okay, now, that has to be pre-negotiated with
yeah. So
your
whatever you're doing,
sponsoring broker.
all has to be done ahead of time. So, I mean, you can't, once you have a listing agreement, the fee is determined in that listing agreement and set there. So if you are gonna do a variable fee, like, here's my fee, but dual agency is, you know, 0.5% or 1% less or whatever, that would have to be acceptable to your broker ahead of time. Or if you're gonna list your twin sister's house and you don't wanna charge her anything, but the broker is gonna insist on his share, for example, even that kind of arrangement is something you probably should work out ahead of time so you know exactly what that percentage will be, right? Because you can't tell your twin sister you're going to pay 3% for the buyer co-op fee and 0.6% for our services, or 1.2%, you know, if you don't know what that split is. So even there, as occasionally I'll see brokers say, well, I was listing my parents' house and I didn't want to charge them anything. And most sponsoring brokers are perfectly okay. If you don't get paid anything on a deal, they'll try to talk you out of it, but they know you might not want to charge a friend or a family member or something. But then you need to know how much does go, because the broker's going to insist on their piece of it. Right? So whatever that is, you're going to want to have all that worked out ahead of time.
So that's when you're hired on.
I never had any problems with my sponsoring broker pushback if I offered something less on a dual agency kind of arrangement. But I'm also trying to remember if we had a minimum percentage in our employment contracts. I don't even remember. But, you know, I mean, I've toiled under several employment contracts, but one of them I never did any business under because it was only for a year and I was just kind of kicking the tires on at the industry. The next one is the one I'm talking about, and I don't remember a minimum fee. And so even if we had one, I may never have hit it even after dual agency, I don't remember. And then after that, I was the managing broker, so I could kind of do whatever I wanted to do anyway. So I don't recall that, but yeah, if you were gonna, if the broker had a policy that said we would never charge less than 4.5%, for example, and you're normally at 5, and now you want to offer 4 for dual agency, you probably need to get that pre-approved. Because if you don't, and the broker signs off on it, they're going to take that, they could potentially take that piece out of your compensation.
Yeah, well, that's kind of what I thought this was referring to, because they said that your main thing is 5%, but then they negotiated it at 4, so when I was figuring it out, trying to come up with the commission,
Yeah.
I based the sponsoring broker at 5%,
Oh.
and the other person on 4, and they ended up making like $1,000 more by doing that, but it's pretty significant, so I didn't know if you needed to do that or whatever.
No, again, yeah, everything has to be figured out ahead of time, because the commission is just the agreement really between the broker. You know, again, you're involved only because of your employment contract, so it's, you know, between the broker, you're really negotiating on the broker's behalf whenever you do negotiate a commission as part of a listing or a buyer agency deal. Is that okay? That helps?
That's good.
Okay.
But I do have another one.
Yeah, go ahead.
Number 18.
Okay.
Okay, it says the seller wants to net $108,000 from the sale of his home.
Right.
He must pay his broker 6% commission, and what would be the selling price?
Right. So this was that upside down backwards thing.
Right.
So we know that the seller needs to net 108,000, right?
Right.
So what we need to figure out then is what, you know, times, well, and what the seller's gonna net is 94%, right? So if we had all the information and it wasn't a problem to solve, we would have a sale price, that's our variable here, right? We're gonna have a sale price times 94% is gonna equal the net dollars to the seller.
Okay, can you
So-
figure that out? Because I think this answer's wrong.
So what we're missing is this. So it's 108,000 times 0.94. Oh, excuse me, that's not the sale price, excuse me. It's our variable, rather, right? The sale price times 0.94 equals 108. So in order, what it's gonna look like then is you divide each side by 0.94. So the way to get that then is this: the sales price is gonna equal the net dollars divided by the net percent. So 108 divided by 0.94 is gonna get you something higher than if you took 108 and added 6%. That was the caution in the class when we went through the math. You can't just take 6% and add it to 108. And when you write a test question for the state exam, if it's a math question, they insist that the students can calculate the wrong answer. So I mean, there is that. So I think in that trial problem, right, if you took 108 plus 6%, you'll get a wrong answer. And that's what you should expect. I may not be quite that harsh in the final. I don't remember. I probably am. Because at the state exam, you can't get a math question through review if you can't miscalculate at least 2 of the 3 wrong answers. You know, I mean, so you have to have the right answer, a couple that you can use the numbers in the problem to get the wrong answers, and then maybe a 4th one that's a flyer. But you know, so.
Okay, and then also when you're figuring out, the other thing was, they were, I guess they figure a 30-day month
Yeah,
on average.
that's very common. That's not all. When we get to chapter 23, we'll look at this again, but yeah, the 30-day month is statutory. A banker's year, which is very common in finance, is 12 months of 30 days. So a 360-day year. You may even have bank accounts that work that way for interest or loans that have worked that way and not ever know it, but that's how they, it's usually favorable to the bank, of course, but that's how
You know,
they
I
do
sat
that.
for 10 minutes trying to figure out if there was 360 or 365 days in a year. I'm like, something doesn't sound right.
Yeah, I always use a 365-day year in practice, and the few closers that I have asked about this, title company employees who close things, have told me they also use that. But I've been told that the problems at the state exam, and so you'll see them in the course of, certainly, are done based on statutory month of 12 months of 30 days.
Okay. That's good to know.
I've had that happen in practice where I had to calculate something, and I literally sat there and thought, well, which method works out better for me? And then I used that method, and the difference was $5, and nobody asked, and, you know, just.
And for the state board, it's 30 days.
Yeah, that's what I'm told for the state exam. I don't know for sure, but yeah. Any other questions?
I got a question about the testing,
Yeah.
so.
Let me close that back door. Go ahead.
One of the questions that I got wrong was, and I'm just trying to go off the top of my head, where they had negotiated a deal of 6%, and in the question it said that there was extra work that had to be put in, so they renegotiated a verbal for like 10%, and then when it came to closing, it was only going to be paid 6%.
Right.
And the way I understand things, a verbal contract is just as good as a written contract from a state standpoint, so is,
We'll touch on this more when we do contract law, but it's a basic principle of contract law, basically, that no oral agreement will ever override a written contract, ever. So there's a term that I don't think is used in the textbook at all that you could potentially see at the state exam. It's called the parole evidence rule. And parole, P-A-R-O-L, the parole evidence rule basically states that when you have a written contract, it will supersede every oral agreement you have before then. So it's a basic premise that if you sit down and say, well, let's use a car dealer, for example, where they're providing you and you're negotiating the contract with them, and they say something like, you know what, you're looking at the final contract, and it doesn't include the rust proofing and the years worth of car washes that they said they would give you, and they say, oh, don't worry about it, we're good for it. You should never sign that contract because they don't have to provide it. The moment you sign that, then whatever they promised you orally is completely gone. And you can say, well, it's them, it's not their word. Even legally, there's no way you can force them to honor that, and legally they have no obligation to do so, maybe morally or ethically. So just the basic rule of thumb you'll want to use for contracts of any type is that no oral agreement will ever supersede a written contract. Now, if you could demonstrate, for example, that you had there was some proof that once there was a written contract, it was modified later, like an email trail, just from the party who said, I'll pay it, even though there wasn't a written confirmation, which would be what would be required to actually form a contract. A court might accept that.
That would be-
because the party who's being asked to be burdened, it has a smoking gun in their hand, right? Because there's an email that they wrote.
Right.
But if it's the other way around, which it typically is, where there's the person saying, hey, I was told this, and there's nothing in writing from the other person, you got nothing. And that's it's a little bit of a cart before the horse question, right? Because we really haven't gotten to contract law yet. And that happens somewhat in the class. So if sometimes you really can't sort of grasp all this stuff until you've seen the bigger picture when we get there. Other questions from anybody else?
I had a question.
Yeah, go ahead.
Regarding this, chapter that we're gonna read.
Okay, for chapter 8, all right?
Yep. What would be the point of having a tenancy in common, or a joint tenancy, when you can just make that into a tenancy in common?
Well, it kind of depends upon what you want to accomplish. So we'll answer that when I get there, which won't be about
I
10
figured
minutes
you
from now.
would.
Yeah, that's good. That's a good question to have. And so yeah, I think I'll touch on that. I think that'll be handled. If I do it now, then I'll get all messed up, and I won't sing and dance at the right times, and it'll be messy.
We don't wanna screw up your procedure.
No, you don't, right? Because that's like I have that problem. If I answer the certain question in the middle, then I think later I've answered it and I haven't, and it gets kind of worse than it is already. Good question. Other questions anybody has on the board before we get started? All right, well then let's go ahead and do this. So again, another kind of real estate law principles kind of thing, not necessarily related to agency, but related to property overall. So spend a few minutes on these various forms. Several fees, this is a term you could be asked at the state exam. It's a little bit of a backwards term in terms of the word several is in there, so that I think they point out in the text, you want to think of it as being severed or cut off from others. Even a multi-ownership entity can own something in severalty. What do I mean by that? So you can have a partnership that has 8 owners, and each of those 8 owners might have an interest, of course, in the partnership. But the partnership itself as a whole could own a piece of real estate in severalty, because only the partnership owns the real estate. Right? So 10 million people could own stock of General Motors, but General Motors itself could own its manufacturing plant in severalty. That makes sense? All right, so don't try not to get too hung up on that. I don't think I test you on that term, but it's worth knowing at the state exam. I'm much more concerned that you understand the difference between these various co-tenancy forms, which is something we'll spend a little bit of time on, which gets to Ken's question, which I'll try and address in a little bit of detail here in just a minute. So the kinds of test questions you can get about these 3 different co-tenancy forms will sometimes put all 3 of them in a picture, and then you have to figure out which is which. We'll give you a set of fact circumstances, like A, B, and C own the property jointly. B dies, now A and C own the property. What happened? How did they own the property before? So what ends up happening is understanding the differences of these 3 forms, particularly between tenancy in common and joint tenancy, is helpful. That way you can dissect that out of a fact-based kind of problem. So what makes tenancy in common unique is each party has this undivided fractional interest. So if you co-own a large piece of property with a tenancy in common interest, and you own 1% of the property, that does not give you right to say own to a particular 1% of that piece. It just means you have a 1% interest, like owning stock in GM. You can't own 1% of General Motors and walk into the factory and say, I want 1% of the cars that come out of here today, right? You have no such claim. You just own 1% of the profits, basically, and the losses, that's all. The tenancy in common works the same kind of way, an undivided fractional interest. Now, tenancy in common, unlike the other 2 forms of co-tenancy, is inheritable. In other words, if I want my interest in a co-tenancy format to pass to my heirs, the only one of these 3 that works is tenancy in common. If it's joint tenancy, or if it's a tenancy by the entirety, it's going to my co-tenants when I die, regardless of what my will says. So it's a little bit of a state law versus personal desire. So in my will, where I state my personal will and volition, this is where I want my property to go, but if I own it in joint tenancy, it ain't going where I say, it's going where state law says. We'll cover that again in chapter 12, but that's just something to understand. Only tenancy in common is one of 3 where there's no right of survivorship. You can pass your interest separately from all other interests directly to your heirs. Tenancy in common, likewise, is the only one of these 3 where you can have varying percentage interests. So in a tenancy in common, I can have a quarter, you can have a half, somebody else can have, 2 other people or 3 other people can split the remainder. everybody can have a different piece. And that's an important concept for probably the most common place you're actually ever going to see this is either an investment property or as the type of co-tenancy interest you have in condos, is tenancy in common, in the common area. So again, completely doesn't matter. Each co-owner can have same, different, whatever it doesn't make any difference. Again, it's the only one of these three where that's the case. In Illinois, the default arrangement, in other words, if the deed itself or the will, whatever document it is that's used to create the tenancy in common, or excuse me, whatever is used to create ownership, to convey ownership, if it is conveying to co-owners and it does not specify how those co-owners are taking title, then the default, the automatic response is this one, tenancy in common. The kind of place where this can happen, for example, is in a divorce. There could be a divorce decree and a quitclaim deed that takes one person off the title. And then, well, or that doesn't even do that. Excuse me, just a divorce decree. If your tenants by the entirety, which will come to an end, you have to be married. So now if you're no longer married, what happens? Well, you still co-own the property, but you're automatically by default going to be tenants in common unless the decree specified joint tenancy. So in other words, if whatever document it is, usually a deed, the next most common is a will, and then after that some other kind of document, like I was saying, like the divorce document, you're talking about tenancy in common if it doesn't specify. At least that's how it works in Illinois. We'll look at some deeds in chapter 12, and in there you'll see exactly what a deed looks like and how that conveyance language is typically very clear. But again, if it's not, tenancy in common is the choice. Now, some clever investment people have used TIC, or tenancy in common, as an investment mechanism over the past 10 or so years. It was fairly common in the booming years of 03, 04, 05, 06. The idea is that a lot of people want to invest in real estate in a very big way. They want to own a piece of a major condo development, or they want to own a piece of an office building. So you, under a tenancy in common kind of arrangement, you can pool a lot of money together from a lot of regular folks like us. 1,000 here, a couple grand there, and all people have is tenancy in common interest, which you can sell, you can will, you can give away, you can do anything you want to do with it without affecting the relationship of all the various tenants in common. So it's been a way to pool a lot of money to do big deals where most of your investor money is not sophisticated. Not all these tenancy in common deals ended very well when things went bust. And so it's something that probably out of favor, and maybe for good reason. Not because the mechanism doesn't work. So what would happen with this kind of a TIC sort of investment is that you get one party who pool the money together, and they would have a controlling interest through whatever arrangement, a management agreement, whatever. And they would control it, and every other tenant in common had no idea who their other co-tenants were, had no way to contact anybody, much less control than if you were a shareholder in a publicly traded company, for example. So that kind of thing is not, again, probably not advisable, not unless you're the person controlling the purse strings, in which case it's a clever way to raise money. And then ending a tenancy in common is pretty straightforward, right? I mean, all you have to do is get out of it. You just sell it, get rid of it, whatever. It's fairly straightforward. There's no need to partition such a thing because you can just transfer your title whenever you want. Questions at all about tenancy in common? More commonly used and probably more important to understand is joint tenancy. Now, these various ownership forms we're looking at aren't just for real estate. So joint tenancy is very common with bank accounts, for example. Any of you who are married or in any similar kind of relationship might want to look at your bank statements. Because if it says this on the top of the bank statement, joint tenancy with right of survivorship, what that's telling the bank is when one of the two of you who owns the account dies, the money automatically belongs to the other person, right of survivorship. So the bank does not need to worry about whose money is in the account and can they let that other person have access to it. So my wife and I own as much as we possibly can in joint tenancy. For whatever reason, that's just what we've done. So when one of you murders me before the course is over, she gets everything in the bank accounts, etc., and it's automatically hers. She doesn't have to prove anything. She doesn't have to do anything. Doesn't matter what my will says or if I even have one. Bam, all that stuff is hers. That's the right of survivorship.
Do you have to be married in order for that to happen?
No, not at all. So when my middle daughter wanted to buy a car, she was going to college, she and I co-purchased it, and we owned it in joint tenancy. So that if I died, her car would end up being her car. And if, God forbid, she had died, it would have ended up being my car. And that was how we did that. Now we didn't have to have, who's gonna own it and all that kind of stuff. It's just a simple way to do it. Well, anytime you have co-owners of vehicles, that's probably the default in Illinois of what they expect the ownership is on that title. So that's the beauty of it. You do this now if this is what you want. So back to your question, Ken, about why have a tenancy in common, because you don't want that. So let's just think about a married couple co-owning their principal residence. You haven't even gotten the tenancy by the entirety, but I don't want to forget this question. Why would somebody choose tenancy in common over joint tenancy or tenancy by the entirety if you're a married couple and you're talking about your principal residence? Under what circumstances would you not want your spouse to inherit your piece of the property automatically? Well, it could be, but even more commonly today, a lot of people have a second marriage. My aunt and uncle had second marriage that lasted 20-some years. They'd each been married 30-some years before that. This is very common today. We're living into our 90s, beyond. An uncle lived to be 102. So, some people in their second marriage, it's 40 years. So, if you have children from the first marriage, you may want your interest to go to your kids, in which case you don't want state law to determine that it has to go to your co-tenant. Tenancy by the entirety or joint tenancy would require that interest to go to your co-tenants when you die. Tenancy in common allows you to direct it via a will. So that's a reason why you wouldn't want one of these forms, or would. It comes back to estate planning.
Well, that was the question. Why would you have joint tenancy when you could just make it a tenancy in common, which seems like there's more control there instead of having the right of survivorship?
Well, for me, for example, if I have things set up in joint tenancy, most of the stuff that I own with my wife, if my wife and I sell our house and property here and I retire and we move to some other state, my will may not be valid or make any sense. But joint tenancy will work everywhere in the country. So however I've got things owned, bank accounts, property, whatever, it'll automatically be hers, even if my will isn't properly proven or if there's some other problem with it. So as part of my estate planning, I want those assets to go to her, and vice versa. But if we didn't, then it would be a bad idea. So you really have to kind of look at that holistic view of what are you trying to accomplish and what do you want to do. Which is really, one of the reasons why everybody should have a will, and everybody really at some point in time should either sit down with themselves and LegalZoom or some other software or hire an attorney. You can get a pretty simple will drawn up for about $300 or $400.
So this would be a good idea if you didn't have a will in place then, and especially if you wanted everything to go with your spouse.
Mm-hmm. Or whomever your co-tenant was.
Right.
You buy something with your twin brother and you want him to get your interest and he wants you to get his, then that's an ideal situation. If the opposite is true, you don't, you want to control the tenancy in common is better. All right, so to create a joint tenancy, it's relatively straightforward, but when you create it, in order to have it be a joint tenancy, these 4 unities all must happen. So people who have a title, who have interest in the property rather, must have obtained it at the same time. They must have gotten basically the same interest and received it via the same document and have the same rights. So that's what these 4 unities are basically saying. Anytime you're a joint tenant, you have an exact same interest as each of your fellow joint tenants. That's the requirement of that. So again, if that's not what you want, then maybe joint tenancy doesn't work. If any one of those 4 unities is broken, then it cannot, by law, be a joint tenancy. Which is where they get into in the book, A, B, and C own something as joint tenants, A conveys to D, what happens, B and C can still be joint tenants because they still got their interest in the same way, but now D is going to be a tenant in common with B and C who are joint tenants with each other.
So you can have both in the same situation?
Yes, you can.
Okay.
Absolutely you can. In fact, you would have to if in a scenario where A, B, and C all purchased or all earned together. So again, it can be created by a will. Say A, B, and C are siblings. They each inherit the exact same interest from their parent who passes, and then one of them later needs cash and so sells their interest to somebody else. You're now going to have B and C who remain joint tenants. A is gone, and D is now in the deal, and D is a tenant in common because it can't be a joint tenant because they didn't obtain it in the same manner at the same time. So yes, you can have a combination of the two. Okay? You can partition here. Partition is where, you've got these multiple joint tenants and somebody wants out. The other joint tenants won't offer them a fair price, or they can't come to terms. It is possible to basically seek a business or an investment divorce. That's what a partition sale is. You go to court, you ask the court to force the sale of the entire piece of property, real property, personal property, whatever it is. Your Honor, there's a dispute. Me and my two brothers, we all co-own our father's solid gold wedding ring, and we don't want to cut it up, and they won't buy me out, and so I want you to force everybody to sell it. If that happens, then the money goes in, then it's divided 3 ways, and that's the end of it. So the same kind of thing can happen with real estate. That's the reason for partition. Under tenancy in common, there's no reason to do it, and under tenancy by the entirety, there's no ability to do it. The partition suit makes sense with a joint tenancy. So looking at the details, again, time is simultaneous acquisition, whether it's by deed or by will, has to happen at the same time, has to happen at the same document. Everybody has the same rights, the same interests. So if you get one of these questions that, say these 3 parties co-own the property, one of them dies, now these 2 own it, what was the most likely scenario? Could have been 3 people with 3 equal interests. Now there's 2 people with 2 equal interests. And everybody has the same rights. That's the way it has to work, or otherwise it really can't be a joint tenancy. In some states, joint tenancy is the default. As we mentioned, it is not in Illinois, but in some states it is. It depends, this is all state law as to how these things work. Questions at all about joint tenancy? Again, you're really looking to compare it with tenancy in common and tenancy by the entirety. So tenancy by the entirety exists in roughly half the states, and it's joint tenancy all over again, but with a 5th unity. And that 5th unity is marriage. Specifically, marriage. This again comes back to, alternative lifestyles, folks seeking equal rights. You have to be able to have a marriage in most states in order to get this kind of property right. So if you're married, then you and your spouse have this as an option in the state of Illinois. If you're not married, any other relationship doesn't work. Not to allow this. And it's also only for your homestead. It's for your principal residence. So what happens is that under this, basically the married couple are treated like one entity. You cannot partition. So if you want, you co-own property, co-own your house with your spouse, and you want to get divorced, partition suit isn't an option. You can't force the other party to sell. Can't.
A situation, sorry.
That's all right.
Your spouse is in a horrible car accident, right? It's a school bus. Survivor's room.
Yeah.
Whoever comes and sues you.
Okay.
Can they take your house?
No.
There's someone.
No. That's the beauty of this. So this is the unsecured creditor protection. So what happens here, let's say as a real estate agent, similar scenario, less gruesome. As a real estate agent, I cause some major problem, get sued and lose $1 million lawsuit. My wife steps up and goes, oh, hang on, you can't take the house, that's my house. And under tenancy by the entirety, the state of Illinois agrees. So one of the challenges is if you and your spouse, for example, both file bankruptcy, then that would be worthless because now you both caused the loss that could lead to this being broken. If you co-own a business together, and the business, let's say it was the business vehicle that caused the accident or whatever. Now, if both spouses were active and investment participants in that business, tenancy by the entirety might be worthless. So when you sit down and talk to an attorney, sometimes when they're thinking about the holistic view of somebody's estate and estate planning, they'll look at tenancy by the entirety at the same for the house. At the same time, they'll look at, well, who owns the business, and try and make that in such a way that if the business is a big risk, it's only owned by one spouse, which of course is a risk if you have a pending divorce, or if you have a divorce later or whatever. But that's one of the reasons why they kind of look at that big picture, because again, if you co-own the business, then this is worthless. So this is the one thing that my wife and I don't own in joint tenancy. We own our house as tenants by the entirety. For whatever reason. It just seemed to make sense. Oddly enough, this is like a lot of things. This came from England, and it's been gone from England for 40 years or longer. But it's fairly new in Illinois, and it's still hanging on and well used in half the states in the country. All right, so again, looking at it, it's basically joint tenancy all over again. Add the unity of marriage. Understand it's really only for your homestead or your principal residence property. You cannot partition, but in the event that you're sued or you get a judgment by any unsecured creditor, again, your mortgage company is not gonna be included in here. So you can include a credit card company, anybody. If they sue you, unless both co-owners, unless both spouses contributed to the problem that caused the judgment, the innocent spouse is going to be able to hide behind this tenancy by the entirety, and that lien will never attach to the house. It can be recorded against the house, but they'll never be able to foreclose on it, because when they try, they'll be defeated by the tenancy by the entirety. Okay? So that's really what distinguishes tenancy by the entirety from the other issues, the other options. Questions about any of those three at all? All right, we're going to talk very briefly, and I mean very, and I promise you I will not ask you a single question on community or marital property. This is not a divorce law class. Thank God for that. One of those was enough for me, and that was my parents, and I never recovered, so my poor wife can't leave. She's chained up at home right now as we speak.
Mhm.
No, she's not, but she got a raw deal either way. So I mean, all right. So I just threw up a few of the states. Community property is kind of a different way to look at things. If you look at community property as opposed to, say, common law property ownership, you'll find that a lot of the states that have community property are Spanish. So what the deal was basically is that law in Spain was much different than law in England. In England, it was very clear that women were treated as property, and under Spanish law, women had rights. Hence the difference. That's really the basic difference. And since then, you've had more of an adoption. Illinois does not. This is probably what's important. Illinois does not follow community property, because community property is kind of one of those. I don't want to use the term common law, but it fits the same bill. It's what was already there. And so that's what those states follow on. But Illinois doesn't do that. Illinois instead has created a statutory construct that follows community property, but we call it marital property. So where community property is kind of whatever the lay of the land was, the law of the land was for centuries before, Illinois has now created a statutory situation with marital property. So it's similar, but has a different name, and you have to look at the statute to see how it works. Any questions about that at all? Again, if you read the book, you know every bit as much about it as I do. All right, back to stuff that matters, and you could get tested on, etc. Trust. So trusts are one of these things that doesn't sort of exist in the natural world. It's a legal construct, something we put together, a legal fiction of sorts that we put together in such wise that we can do what we want to do anyway. So each of these has its own purpose. We're going to focus mostly on land trusts and a little bit on REITs. For test question purposes, I would think that land trusts are probably the most important thing here as well. The parties, this is also important, and we're going to touch on this again when we come to chapter 16, and we're talking about loans, because this idea, maybe it's 15, one of the two of those, it's 15. Trusts are sometimes used in lending. We don't do it much in Illinois, but in other states, trusts are a fairly common mechanism used to kind of figure out who the lender is and what role they play and who the owner is and what role they have and rights they have, etc. So the idea of a trust is the trustor, that's you, whomever sets the thing up. So if you create a trust, you're considered the trustor, the one who does the deed. If you haven't figured this out yet, by now you will, but the OR is the doer of the deed, right? I mean, theoretically, I'm the teacher and you guys are the teachees. That's, you know, kind of where this language comes from. So the trustor is the person who sets it up originally. The trustee is whoever's going to hang on to that. The party who acts as sort of the neutral third party to control the assets without necessarily having, by virtue of being a trustee, without actually having any right to use them for any particular purpose. Trustees are sometimes banks. So you see it in the name, Old Second National Bank and Trust. Trustees are sometimes title insurance companies. Depends upon what the role is. The beneficiary, or the owner of the beneficial interest, is the party who's going to receive the benefit of whatever is being held in trust, whether it's real estate or something else. So those are the three parties. The person who sets it up, the person who controls it, manages it basically, and the person who's entitled to receive it. Sometimes two of the three of these are the same. Depending upon which type of trust, it changes who can be the same and who can't. So let's talk about that a little bit. So a living trust, you set it up and it starts to take effect while you are alive. Clever name, living trust. It's working and there and functioning as you are living. So in the case of a living trust, the trustor and the trustee are in fact the same people, or can be, usually are. And it's the beneficiary who's a different or third party. So an example of a living trust, if I have my story correct, is what Ted Turner did with UNESCO maybe, 10 years ago? Whenever Ted Turner, Atlanta Hawks fan, we mentioned him the other night, owns a lot of real estate across the country. Atlanta Braves fame, and Turner Network Television and all that kind of stuff. He gave a third of his holdings in Time Warner Company, which had bought out his business before, to the United Nations. Specifically UNESCO, UNICEF, that kind of thing. But Ted's still alive, and Ted's still voting those shares of stock. What Ted did was he put it into a living trust. So the stock goes into the trust so that it's there for the benefit of this cause he believes in, the UN and international goodwill and all that sort of thing. But he controls it the same way as he did before. So he doesn't get the dividends out of it. Those go into the trust. But he set it up, so he's the trustor, he manages it, so he's the trustee, the beneficiary is UNESCO, UNICEF, whomever. Once he dies, of course, then he can't be the trustee anymore, and there'd be some other entity probably. So although he wanted to give them money, a large amount of money, he didn't necessarily trust the UN with those resources, nor will he ever, apparently, because he's going to hand that trust off to some third party to manage, because he figured what would the UN do? Probably sell the stuff, money's gone, and they would use it for administrative expenses or whatever. So when something is yours, depending upon what you want to have done with it, you can continue to control it even after you're dead if you structure it right. And a trust is one mechanism to do that.
I thought it had to be set up legally.
Well, it is.
Oh, it is.
But it is
It's
set up.
still,
Yeah, that's how a living trust works.
okay.
So, again, he set it up. And, however, whatever mechanism he used, he conveys a third of his stock into that trust, and the UN, whoever the beneficiaries are, receive the benefit of that money, but he controls it. So when it comes time for stockholders meetings, he votes all the shares, the same as he did before. And it's kind of genius, because he's looking at that going, well, I can make a big splash, I can make a lot of news, good press, and I can sort of maybe get people to warm up to the cause of supporting these international efforts by saying I'm giving away a third of my fortune, when he had no need of the money from the dividends, and he had never had any interest in selling. So why not give a third of it away? Didn't give up anything, really, in terms of control. That's what a living trust is good for. Now, a testamentary trust is a little different. You still set it up while you are alive, you have to, otherwise it wouldn't exist, but it doesn't take effect until you die. So here the trustor and the trustee cannot be the same, because when you have a trustee, that responsibility kicks in, you're gone. So it's in your will, which again you create while you're alive, but it doesn't take effect until you're dead. You could do the exact same thing with a testamentary trust that we just talked about with a living trust, but it takes effect through your last will and testament, hence the name. So that's a testamentary trust. Now land trusts, a little bit different animal. Here, in a case of a land trust, the trustor and the beneficiary are usually the same people. So if I'm going to set up a trust and I'm going to receive the benefit of what's in the trust, what's the point of the trust? Good question. It all comes down to anonymity. Large owners of real estate, or people with a lot of assets who don't want their name in the public record, hence my reference here to chapter 13, can put their property into a trust that they can control as the trustor and the beneficiary, and have it show up in the public record as Old Second Bank Trust Number 1234A, as opposed to Cliff Luxon, and now they know what to go after if they sue me. Real estate development companies, doctors, lawyers, people who have a lawyer and the lawyer advises them to do this, anybody who just doesn't want their name in the public record can set up and use a land trust. Very common way to hide ownership. It's a great way to acquire property in particular, where you don't want people to know that you are the acquiring individual or entity. Does anybody know of any examples of the use of land trusts that everybody in the room would know what we're talking about? When I moved into my neighborhood, how many of you are familiar with Billy Williams? He's the last surviving kind of 1960s Hall of Famer from the Chicago Cubs. Billy lives 3 doors down from me. Wonderful man. So when I moved into my neighborhood 12 and a half years ago, my then 21-year-old daughter kind of got all excited, and I showed her how to use the MLS before that. She'd been helping me for 5 years by then. But we drove by this man who at that time was the first base coach for the Cubs. He was still working for the team, actively in the field. I was just driving to my house with a load of stuff in my car, and I thought, my God, that man looks familiar. Why does he look so familiar? And then it dawned on me as I'm pulling my driveway, holy crap, I think that was Billy Williams. So I mentioned something to my daughter. I drive back to our other place to get the next load. When I come back a couple hours later, she goes, it is him. She looked him up in the property records. Just that simple. So if you don't want your name that obviously available in the property records, what do? You set up a land trust. So it's not that complicated to do. And again, number one value, anonymity of ownership. It's potentially a way to avoid litigation, right? Because if you don't know that you own a bunch of land, maybe somebody won't sue you to try and take it away from you. Same thing, it's harder to lien something if you don't know it's there. You got to hunt and hunt and hunt and hunt and hunt. Where do you look? How do you do that? It's very complicated. Because it's a trust, the ownership is already predetermined. Whoever owns the beneficial interest can inherit it. So it doesn't automatically, like when a land trust where it's conveyed to yourself doesn't really help, but you can, in a land trust, have a different third-party interest, in which case it could avoid probate, which is something we'll talk about again briefly in chapter 12. Puts control within the trust. So if a real estate investment company owns a bunch of different properties with a bunch of different partnerships, etc., you can have one trustee, the developer, that could control all of it. The beneficial interest is kind of an interesting sort of thing. You don't need to know too much about all these details. The main reason to do this, again, is to just keep your name out of the public record. And probably the best 2 examples I can give you, besides my neighbor who didn't do it, would be Sears Tower. In the late 1960s, early 1970s, when Sears was doing that, that was kind of a secret. They were replacing a major headquarters in the western area of Chicago called the Great Works, and when they decided they wanted to build a high-rise, they started acquiring the property, and I think they purchased it from like 13 different sellers. It was not only a full block, which if you've been to Sears Tower, which is now called Willis Tower, you'll notice that it's a full block, but actually Quincy Street ran through the middle of it, so one of the sellers was actually the city of Chicago. Sears paid, I think, $2.5 million for a 1-block stretch of Quincy so they could build the high-rise there. Well, what would have happened to all those, and it was a very seedy area, if any of you were down there in that area, I'm not going to say this again, so Cecilia doesn't have to say something like, I wasn't even born then. So you won't have to do that. Yeah, that's right. But that's okay, I have this all the time. The more I teach, the older I get, the more I realize that's the case with most students. So in the early 1970s, that part of Chicago, which is very close to Metro and Union Station, was quite seedy. A lot of people didn't want to come in by public transportation. They didn't want to walk into those old dilapidated areas to get to the better part of downtown, which was closer to the lake. So what do you think would have happened to the property values there if they knew that it was Sears, then the world's largest retailer, that was buying up all those individual properties?
Property value
would have gone up a lot. And Sears would have had to pay a lot more money. In fact, the last property owner might have charged them, who knows? So one of the reasons to use a land trust, again, is because that anonymity, you also don't know who the buyers are. Each parcel could be purchased under a different land trust name and number. You can't even tell that one party's acquiring all the parcels. And then there was a major development in the 1960s in Central Florida, following on the company's success in Southern California. Disney World. Disney kept that almost a complete secret. They were very close to the end. And they made more noise, actually, than they intended to, but nobody knew it was Disney. There was just speculation that it was some major entertainment company because the parcels were being acquired, but they didn't know for sure who it was. Same kind of thing, 43,000 acres or some crazy thing, with square miles, whatever. Disney owns a huge chunk of property in Central Florida. So that same kind of thing. So anonymity of ownership could be valuable. When the Toll Highway Authority extended 355, a lot of the property owned very close to 355 and I-88 was owned by a real estate development company. As it turns out, that real estate development company had one executive who was actually the father-in-law of Tommy Morse, who was the Toll Highway Authority's 28-year-old executive director at the time. So today, there are laws in Illinois that oftentimes you cannot sell to a public body until the owner of the beneficial interest in the land trust is laid bare. You have to disclose that, because otherwise, funny things can go on. Land trust is a great way to hide things. In other words. Any other questions at all? Oh, I know. This is a mention I mentioned before, a trust agreement. Within that trust agreement within the land trust, that's how you sort of dictate what authority the trustee has, which is usually very little. When the tax bill comes in, maybe, the trustee will probably not pay it. They just forward it back to the trustor who writes the checks to pay it. When the lawn needs to be mowed, snow needs to be plowed, building needs to be maintained, all that stuff is covered in the trust agreement. If you've ever owned a piece of property in a trust, it can be kind of a pain, because now you want to refinance your house, but it's in a trust. You have to go to your trustee and have them sign the documents necessary to give you the authority to refinance your own place, because you gave them that position in the first place. Trusts have a temporary life. I had a situation one time where I was managing a bunch of assets, and a trust expired, and we couldn't find a third signer, or a second signer actually. One signer had died, one was incapacitated, and the third signer existed. So we couldn't renew the trust, we couldn't convey the property, we couldn't do anything with it because the trust had expired. So it was a very awkward kind of situation. I'm personally not a big fan of land trusts, but they have their place. You had any questions about that before we move on? All right, so be familiar in general with those various forms of co-ownership and trust. All right, so we're going to talk a little bit about business organizations here. This is kind of straight out of a chapter of a business law class or intro to business class, whatever. So if you've taken anything like that, it's kind of similar. And there are two possible uses for this knowledge that you're going to get here. One is how you want to own real estate, and the other is maybe how you might want to own a future brokerage business. When we come to chapter 14 and we look at different kinds of broker licenses, it is not within the purview of this course for you to understand how like a corporate or a partnership broker's license would work. That's a managing broker context. But if you're interested, you can apply the same information to that. I'm going to try and limit this to how it works for real estate and what makes the most sense in terms of investments. Did I skip over something? I think I did. Let me just see. Maybe not. I forget where I put this stuff some of the times. I only looked at this half an hour ago, so I can't remember. Yep, okay, everything's there. All right. So, sole proprietors, that's pretty common. That's, if you're a business entity, that's me as a real estate broker. No business form, it's just me. When I file my taxes, I file a Schedule C, and it goes on the same income tax return as my personal income tax from my income from Levancy or whatever. Partnership's a little bit more complicated. There are several different types that we'll look at here in just a little bit. Each has their own purpose. A corporation, this idea goes back to the 1700s or earlier. The idea was to create a legal person. Now, some states, including Illinois, have passed laws saying corporations are not legal persons, but that's actually atypical. The basic rights had always been to give a corporation the same status as a person, so that you could buy property, own property, have the right to be sued, have the right to collect debts, that kind of thing. Same rights that a person would have. Limited liability company is only about a 20-year-old idea in Illinois. We'll talk about that briefly. It's kind of the, LLCs are the choice du jour. That's the favorite kind of entity. And then syndicates and joint ventures, very simple. I don't really care if you remember them. Probably won't ever see that kind of thing in real estate. So let's go over this in some detail. First of all, the whole idea of what you're going to go through. Right? Two main things are the top two. The issue of what kind of legal liability am I going to have for my business activities or undertakings, whether it's a real estate investment or whether it's your brokerage firm or anything else, and what are the tax implications. Those are the two biggest things. After that, other simple, more functional things like, well, what's it going to cost me and how complicated is it to set up? So this is just a, kind of things you should ask yourself. And what you want to do and where you want to do, it's going to vary. So there's not always a clear and easy answer. I have a friend and colleague who's been asking me for the last year, should I set up an S-Corp or should I set up an LLC? Well, I don't know. I mean, there are pros and cons to either one, and the difference is kind of nominal, and I would set up an S-Corp because I've done it before. But that doesn't mean it's the right thing to do. And most people are selecting limited liability companies today for whatever reason. So for example, in Illinois, it's a little more complicated and a little more expensive to set up an LLC. But that doesn't mean that it's not worth it. You have to decide, where you want to put your money. LLCs have some greater flexibility in terms of taxation, etc. So these, again, are things that matter. What's your ownership structure going to be? How are you going to control it? You or outside management? What's the future need to expand, to raise capital, to grow? That's just a checklist for you to be able to look at. No, I'm not going to ask you all this kind of thing. I'm not going to give you a fact-based scenario in this class and say, which is better, an LLC or corporation? That's not happening, nor do I think you get that at the state exam. The person who can answer that best, an attorney, a CPA with good tax training. All right, so let's look at a sole proprietorship. So easy to create, you literally don't have to do anything. You want to become a sole proprietor, go to your neighbor's garage sale, buy his used socks, and start selling them on eBay. You're a sole proprietor. You don't need a license, you don't need anybody's permission, you don't have to file anything. You just declare income on whatever you make or loss on whatever you lose on a Schedule C on your 1040. That's it. Very simple, very easy. This is the most common form of business ownership. Somebody just operating as themselves. 80% of all business entities are probably sole proprietors, something to that effect. How do you expand or grow? It's just you. Can't sell stock in yourself. Can't really sell your business very easily to somebody else because it's you. Harder to raise money because you're doing it out of your own hip pocket and bank account, basically. So it has a lot of limits. But for somebody who's just going to operate as a real estate broker, this is a pretty good choice. So if you're working for XYZ Realty and you're a sponsored licensee and they pay you and it's credited against your social security number, that's what you're doing. You're operating as a sole proprietor, even though you'll put your name out there as working for whatever real estate company you go to. You're a sole proprietor. That's all I have ever done in real estate. Right, wrong, or indifferent, I've never set up a business entity to do it. Not as a broker. Not personally. You have complete liability for everything you do. So as an agent, you screw something up in a big way, you can lose all your personal assets depending upon how you have them structured or whatever. Right? It's, again, everything is yours. Everything. Good, bad, and indifferent, it's all yours. A partnership. Now we're talking about a little bit different scenario. Now you have partners. And when we talk about partners, we mean that literally, legally, partners. So it's still relatively simple to set up. You have to file it, and you have to kind of report on it from time to time. But there's no requirement for an annual meeting or that sort of thing. It's still pretty straightforward. It's passed through taxes. In other words, there's no corporate or business entity that gets taxed besides just the partners themselves. When we normally talk about a partnership, we're actually talking about a general partnership where every general partner has unlimited liability for all of the actions of the partnership, including those that were unauthorized by their fellow general partners. So it's kind of risky. So if Greg and Jeff decide to form a partnership and Jeff goes off and undertakes some contract, it could bankrupt Jeff. Yep, that's how general partners work. Don't like it? Don't do that. So again, a lot of risk there. Limited partnership has to have at least one general partner. And the idea with a limited partnership is that the limited partners themselves put up cash, put in money, they make an investment, and after that, they have zero say in what happens. This was a fairly common way to raise capital for real estate in the 1960s, 70s, and 80s, partnerships. Even into the 90s, before limited liability companies became the entity of choice. So the property that I manage is a limited partnership. One general partner, which happens to be a corporation, of which I'm the president. So this is how I control it. You have a corporate general partner. As the president and board chair, I control the day-to-day decision. All the limited partners own 70-some% of the thing, have nothing to say about it. They could all band together and have a big party and have hate posters. I wouldn't care. There's nothing they can do to make me sell that property or manage it differently. They have zero control. None. So what do? They get cash, whatever I feel like sending it to them. They can write me a letter and say, hey, I need money, send money. If I do that, I have to make a distribution for all the partners, and I make that sole decision. So who are the people who get into limited partners? Partners are people like doctors, lawyers, high income, high net worth people who had money to invest. This guy, I don't even know, lives up in Barrington, I assume had money. Maybe he doesn't anymore, I don't know. There's some owners of a major insurance agency that's one of the largest in Chicago that has a piece of the deal. And so, that's where you go out to get these investors, people who have money and they want to invest. And you say to them, you'll get cash flow, you'll get tax benefits, and by the way, since you're a limited partner, your risk is limited to whatever your investment is. So now, when Jeff goes out and bankrupts the partnership, the limiteds will only lose their investment. Whoever's a general partner will still lose everything they have, but the limiteds, their loss is limited to whatever their value was or whatever they put up into the partnership. So that's the trade-off. General partners have control, but also have unlimited liability. Limited partners have no control, but also have limited risk. I'm not sure anymore about the structure, but this method that was used is how a fellow who owned a company called Balcor raised a lot of capital and did real estate development. That guy's name is Jerry Reinsdorf, and that's the same kind of structure they put together for the White Sox and the Bulls. So when Reinsdorf talks about being the owner of the Bulls or the White Sox, he's lying through his teeth. He has some co-investors who own more of those teams than he does. But by virtue of the structure that was used to create it, he has control, and that's the part that matters. So when I say to you, my building, my office building, my property in Aurora, I am also lying to you through my teeth. But it makes the same sense as viewing Reinsdorf as the owner of the Sox or the Bulls. It's just easier. You don't need to know about the 21 partners and who they are and where they are who have no control, right? All you want to know is who's the guy who calls the shots. So that could be what happens in certain kinds of arrangements. And so by virtue of having control of the general partner, Reinsdorf controls the teams. By virtue of having control of the general partner, that's how I call the shots on the office building. I couldn't come up with $1 million, ever, and that's how much capital it took to purchase that property the first time. So, that kind of thing is a way to pool resources together. Limited liability partnership allows certain kinds of business entities, particularly doctors, lawyers, whatever, to get together and have a partnership, but to limit the liability of the general partners to only their own ridiculous or stupid acts. So now, when Jeff bankrupts the partnership, he goes bankrupt fully, but I only lose my interest in the partnership, even though I'm another general. So that's what the reason for limited liability partnerships. Again, it has worked well in the past for real estate investment, but limited liability companies are a superior investment vehicle. So I'm probably teaching you a little bit of history here. It still exists, you might still see it. If you work with a partnership as a potential client, you need to know who has the authority to sign. You might need a letter from, a meeting of the partners, or to see the articles of organization or the operating agreement if the partnership even has one. To make sure that the partner who signs your listing agreement or who signs the sales contract or who signs the lease that you're involved in actually had the authority to bind the partnership. Okay? It's an important thing to know. Sole proprietors, you don't have to worry about that. Partnerships, you might. Corporation, legal person. So now we're creating a distinct separate entity, whereas the partnership was just a grouping of individuals bound together. A corporation could be an individual or it could be a grouping of individuals, but the corporation itself is a separate, distinct legal entity. So then gives you the ability to separate control from ownership and separate liability from ownership. So corporations own most of the wealth. When you talk about the amount of business that's being done, most of it's done through corporations. So maybe 80% of businesses are sole proprietorships, but 80% of business or more is done through corporations. It's the vehicle of choice for big, big, big business. So when you're looking at an entity like General Motors or Ford or whatever, you're talking about corporations. Access to large amounts of capital because they can sell stock, they can sell portions of the company without having to sell off parts of the company itself, meaning the plant and the equipment and the inventory, etc. It's a distinct entity. So the way a corporation works is that it has shareholders, right? Stockholders, the people who own a piece of the company. So if you own an interest in the Ford Motor Company, you're a shareholder. And you're entitled to dividends and to maybe vote once a year, and that's pretty much it. You're not entitled to anything else. But at that once a year shareholders meeting, you have the right to elect or to vote for, based upon how many shares you own, the board of directors. And it's the board of directors who controls the day-to-day operation of any corporation. Small corporations, the board, the shareholders might all be the same people. But as the company grows, that becomes completely separate groups of people. So the board of directors, one of their responsibilities are to hire the officers who make minute-by-minute, day-to-day decisions. The president, the chief financial officer, the treasurer, the vice presidents, all of that. So all of those top executives at any major company, whether it's a real estate company or any other entity, answer to the board. And the board answers only once a year, basically, to the shareholders. So that's the mechanism of a corporation, again, distinctly separate. So, the advantages here. I own interest in Ford. If Ford goes out of business, the most I can lose is the value of my investment. Nobody's gonna sue me just because I put 10 grand in Ford stock and all of a sudden every Ford in the world explodes. Nobody's gonna sue me and take my money. The stock is now worthless and I lost my money, but nobody's gonna sue me and take my house. That's the beauty of investing in a corporate kind of entity. Liability is completely separate. Many real estate brokerage firms are corporate entities. Very few are partnerships. Quite a few are corporations. And if you remember, I mentioned early in the course, the state of Illinois allows you as a sponsored licensee to set up your own sole-owned corporation to accept commission payments from your sponsoring broker. You have to be the sole owner, but you can use that corporation for anything you want. And it can be formed in whatever state you want. So it's, again, a fairly powerful tool. The major disadvantage of a typical corporation is double taxation. You have two people to tax. The corporation pays income tax on its own, and after that, if the shareholders are given money in the forms of a dividend, you pay income tax on that as an individual. So where corporate taxes in Illinois now are maybe, I don't know, total corporate federal, maybe 40%. So if you make $100,000 in your corporation in the state of Illinois, 40 grand of it's probably going to go to income taxes, plus or minus a little bit. If you take the remaining 60 and pay it out to yourself and your fellow shareholders as dividends, now you're going to pay taxes on whatever your individual income tax rates are, which could be in the 30-some% rate, again, depending upon your tax brackets. So now what you're going to end up doing is paying like 60% in taxes or 55%, a pretty high percentage overall. So that double taxation is a major negative. So that's that's the main negative of forming a corporation. Costs a little money to set up. It's a little bit complicated. You have to have annual meetings. You have to file, annual filings. You have to pay annual fees. The bigger the company gets, the bigger those fees are. So again, there are some drawbacks. An S corporation tries to solve some of those problems. And this is what I was saying earlier. This is probably what I would form. I've incorporated several of these in the past. So under an S corp, so long as you don't have more than 100 shareholders, this is the current tax code right now, a maximum of 100 shareholders for an S corp, you can set up a business like this and the tax liability flows through directly to the shareholders. So you eliminate the double taxation, in other words. So back to my $100,000 profit example, if it's an S corp, you only pay the taxes at whatever the personal tax rates are of the individual shareholders. Different individual shareholders will have different tax rates, yeah. I was involved in one of those, and every year, whatever the profits were, the company would distribute an amount equal to that percentage of the profits that equated to the highest tax bracket of any shareholder in the shareholder group. There were 39 family shareholders, well, 39 shareholders, a lot of them were family. I'm pretty sure the highest tax bracket was my cousin, the doctor, who lived in Pennsylvania, had property in New York, and I'm pretty sure he was in the 40-some percentile range. So if we were distributing enough money for people to pay their income tax obligations, all shareholders have to be treated the same, so we had to pay out a distribution that was equal to the maximum tax liability. I lived in Illinois, and I didn't make as much money, and so when I got a distribution, I was able to pocket some of it, because it was paid out at a rate to cover my cousin, the doctor, not my much lower income. So, again, that's how an S corp would work. You can convert a corporation to an S corp. You can convert other things to an S corp. Every year you get a K1 as a shareholder because you pay the taxes again on your personal return. If you have an S corp interest and they don't distribute you money, you got to write a check for tax liability. That's why you might not want to vote for an S corp if you don't control what's going on. Again, 100 shareholders is the current maximum. Most of your income's got to be from active activities, so if you win the lottery and you decide you want to set up an S corp and all you're going to do with that money is passively invest in something, you can't do that. has to be at least 75% of your income comes from actual stuff you do, not just pass-through passive activities. And again, today, why set up an S corp when maybe you can do the same thing or get the same benefits by setting up an LLC? Can you have a corporation that's a sole owner? Yes, that would be the whole idea. So if you want to have a corporation used for commission payments from your sponsored broker, that's the type you're talking about, an S corp, and you become the sole owner. You can incorporate it in Illinois, you can incorporate it in Delaware, wherever you want to incorporate it. As long as you're the sole owner, you can use that to receive commission payments. And then the corporation could buy your car, buy your cell phone, do other things, whatever you think makes more sense from a tax standpoint. That's the whole reason, because it separates you from a liability standpoint, but it also gives you a separate vehicle to use for sheltering and separating your business operations from the rest of your personal life. Okay, questions about any of that at all? All right, let's run through this one and then we'll take a break. So LLCs have existed in Illinois for just over 20 years. It can be either as really treated for tax purposes, either as like a partnership where it passes through the individual investors, or it can be taxed like a corporation if for whatever reason you'd want it to be treated like a regular corp. Limited liability, in fact, just like with a corporation, it has to say in the name that it's an LLC. In fact, every time you say something, like Cliff Luxon LLC, it has to say a limited liability company after it in Illinois. It's a requirement. And you have to have a designation with a corporation. It has to say Corp, Company, Inc., Limited, something that lets people know that Cliff Luxon Realtor Inc. is a separate deal from Cliff Luxon individual who happens to be a Realtor member, whatever entity I would choose. You must specifically specify in the name because the party you're doing business with has the right to know that they're not doing business with you personally and that your liability is limited. It's part of this LLC corporation sort of thing you have to deal with. You can have a single member LLC. This will not work for commission payments in Illinois as far as I know. They've never expanded the law to allow for LLCs instead of an S corp. So you still have to stick with an S corp to receive payments. But this kind of LLC, this kind of entity, an LLC, is what most real estate investments use today. Special purpose entity, or single purpose entity as they call it. So it's a little more expensive to set up in a corporation. I think it's a little bit more grief after that. You don't have to have, I don't think you have to have annual meetings for an LLC, so it might be simpler to administer from year to year. Corporations live in perpetuity, they live forever. LLCs are usually temporary, 20 years, 30 years, which is long enough for a real estate investment, but maybe not be long enough for your brokerage firm or your personal business activities. So it has its drawbacks. I think I talked about a lot of this stuff already. I just want to see if there's one other thing I wanted to mention with LLCs. Yeah, I guess we'll do that. All right, let's take a break. I'll run through this really quickly when we come back. We'll do 5 till, that's about 12 minutes, unless you're back sooner, and we'll start back at that point. Hopefully it's working for you.